Well, good afternoon, everyone. It's great to be here. Although I must confess, it's a somewhat chastening experience to have been immediately preceded by Justice Edelman. We have slides, so there we go. Well, it is often said, especially in academic circles, that Australia is the only democratic country in the world without a bill or charter of rights at the national level. And it's also argued that we need one so as to better protect human rights in Australia. And so this leads to the question, would having a national charter of rights better protect human rights in Australia? Yes. No. But there is a potential way of testing this claim. So we have just lived through a period where we've seen the most severe restrictions on human rights in living memory imposed by Australian governments. Many of those were imposed by state and territory governments. And human rights legislation exists in 3 of those jurisdictions, so Queensland, Victoria and the ACT, but not the others. And those restrictions were largely imposed by the executive under primary legislation. And in many of those jurisdictions, the validity or lawfulness of those directions was challenged, including those which are blessed with human rights acts and those which are not. And so this enables an intriguing comparison. Did the Australian jurisdictions with charters of rights fare better at protecting rights during COVID than jurisdictions which do not? So here's my working hypothesis. The existence of a Human Rights Act made little difference to legal challenges to the validity of those restrictions. And so this is not the whole picture as comparing, but it is at least part of the puzzle. So did those jurisdictions which have Human Rights Acts make a difference to legal challenges to the validity of those directions? Now it's important to understand Human Rights Acts in light of the Australian model of constitutionalism. Now, academics like me like to use big words like constitutionalism to make us sound more intelligent, and I need all the help that I can get. So by constitutionalism, I mean the distribution of decision-making power among the branches of government and how rights are protected. So constitutionalism is the mechanisms by which government is structured and held to account. And the dominant model of constitutionalism worldwide today is arguably legal constitutionalism. And that argues that legal mechanisms, such as a judicially enforceable Bill of Rights, are more effective in holding the government to account and ensuring that rights are protected. And this is based on the idea that the political branches of government are inherently subject to the whims of majoritarian politics, and politics is often capricious and uninspiring. And with apologies to any politicians here present, there's probably a lot of truth in that. Political constitutionalists consider that political mechanisms are more effective and they're more democratically legitimate in holding the government to account than legal mechanisms. And so they argue that there is no consensus on rights or justice that exists prior to and antecedent to politics. So that is, rights are inherently contested and contestable. And so how we balance rights is something that we need to discuss and talk about and work out through the political process rather than in the courts. We all believe in free speech. We all believe that free speech is not absolute, but we disagree on where to draw the line, precisely. And political constitutionalists consider that it's undemocratic for judges to possess the power to invalidate legislation on the ground that it infringes rights or liberty. So they're the 2 main models of constitutionalism, structuring government and allocating decision-making power. The Australian model is a hybrid. It contains a mixture of both political and legal elements, and both have an important role to play in our system. So the most obvious element of legal constitutionalism is the existence of a written constitution, which is a form of higher or fundamental law, and that applies throughout the Australian Federation. And that constitution places legal limits on legislative and executive power, and there's an independent judiciary that's empowered to enforce those limits. Australia has no constitutionally entrenched Bill of Rights, and there are very few rights enshrined in the Constitution. The Westminster tradition of responsible government is a core feature of the Australian constitutional system. So under the Westminster system, the functioning of Parliament and the mechanisms of accountability are inherently political. So the government is drawn from and accountable to Parliament and through Parliament to the people. Samuel Griffith, who you may have heard of, had a deep impact on the provisions of the Australian Constitution which relate to responsible government. And he was a very articulate proponent of an evolutionary understanding of responsible government. So the Constitution doesn't entrench much, but it allows flexibility for responsible government to adapt and change to the needs of the time. So that's an example of a strongly political aspect of our system. Australian law also recognises a strong distinction between law and policy, and it's the political branches that are responsible for determining and implementing policy, and the courts rarely invalidate legislation on the ground that it infringes rights. Now, there are several reasons why the Australian legal landscape has these features. So one is the constitutional principle of popular sovereignty. So Alfred Deakin, as you all know, was a contemporary of Samuel Griffith. Deakin was more interested in poetry than law, so he was more eloquent than Griffith, but Griffith was certainly a better lawyer. And in 1891, Alfred Deakin said, "We cannot afford to have in our constitution any man exercising authority unless he derives it from the people of Australia." So that the principle of popular sovereignty and popular legitimation of the institutions of government. So as I think Amanda Stoker said before, if our governments make decisions that we don't agree with, they can be voted out and replaced. But by contrast, courts are independent and impartial, and we can't vote them out if we don't like their decisions. A second reason has to do with the institutional expertise of courts. Judges are expert in interpreting and applying the law, but have no particular expertise in public policy or what laws would best promote public health in a pandemic or would promote economic efficiency. The court's role is to authoritatively determine controversies and determine the law in so doing. And the final reason is that while government ought to respect and promote rights, most rights are not absolute but may be limited, and it's sometimes necessary to limit rights to promote other important policy goals. And so where do we strike the balance between rights or between rights and other goals? Well, these are contested questions of policy that parliaments and the executive are best placed to answer. Human Rights Acts have been enacted in 3 jurisdictions. So there's the Charter of Human Rights and Responsibilities Act in Victoria, and there's the Human Rights Acts in Queensland and the ACT, which I'll just refer to collectively as Human Rights Acts. There's also a Parliamentary Scrutiny Act at the Commonwealth level. And Human Rights Acts exist within the broad framework that I've just sketched. And so evidently enough, Human Rights Acts are intended to protect rights, and they do this by listing a catalogue of rights that Parliament seeks to promote, such as the right to life, the right to freedom of expression, and the right to freedom of thought, conscience and religion and belief. And the Acts then operate to protect those rights in the following ways. So first, they provide that any bill introduced into Parliament must be accompanied by a statement of compatibility, which states whether the bill is compatible with human rights. And the purpose of that is not mere window dressing, but it's to ensure that rights are taken into account when developing policy and legislative proposals, in theory. The second way they protect rights is that they require legislation to be interpreted consistently with human rights to the extent that is possible, consistently with the purpose of the provision. That's a fairly limited power. In essence, if there are different constructional choices available, then the courts should lean in favour of a rights-friendly interpretation. Another thing that these acts do is they impose obligations on public authorities or public decision makers, and they impose both a substantive and a procedural obligation. So the substantive obligation is that public entities must act in a way that's compatible with human rights, and procedurally, when they make decisions, they must give proper consideration to human rights. And acts or decisions that don't comply with this may be held invalid. Now, Human Rights Acts can arguably be seen as an attempt to incorporate elements of both legal and political constitutionalism, but without disturbing the fundamental contours of the Australian legal tradition. So the courts have a limited power to tilt the interpretive balance in favour of rights, and there are some additional grounds for holding the actions of public entities to be unlawful, but the courts don't have the power to invalidate legislation on the grounds that it's incompatible with rights. So subject to applicable constitutional limitations, Parliament remains supreme and has ultimate responsibility for enacting legislation. A further point is worth noting just briefly, which is that Human Rights Acts recognise that rights are not absolute, but may be limited under the principle of proportionality. So that is, human rights may be limited to further other legitimate purposes that can be demonstrably justified in a free and democratic society, provided they don't infringe the right to an unreasonable extent. So that is, both legislation and executive action may infringe rights, provided the benefit outweighs the burden on the rights. And And in many ways, I would say, others will differ, but the role of the courts under human rights acts, especially in Australia, is a relatively muted one. Courts have said they won't overzealously scrutinise the extent to which public entities have given consideration to rights, and they can't rewrite legislation. Okay, so in light of what I've said, human rights pose an interesting tension relating to the role of the courts. And so there are two main critical narratives about charters or bills of rights. So if charters of rights confer powers on courts to overturn legislative or executive action on the basis that they infringe rights, or to rewrite legislation in a more rights-friendly way, then there's a risk that courts may overstep their legitimate role and interfere with decisions made by the democratically elected branches of government. To use another big word, that's the counter-majoritarian difficulty. But on the other hand, if human rights acts are not judicially enforceable, then they may add little to the existing law, so they may generate a lot of heat but little light. Okay, so what I wanted to look at now is the COVID cases. I don't think it's controversial to say that the measures taken by Australian governments in relation to COVID were major restrictions on human rights. In Cotterill and Romanes, Justice Nile noted that lockdowns were a significant limitation on rights of a kind that have rarely, if ever, been seen in Victoria. So, how did the courts respond to legal challenges to COVID-19 restrictions? And what difference did a Human Rights Act make? Well, what I want to do now is step through the cases to show how the courts responded, and then I'll draw some common themes and conclusions at the end. So it's meant to be a bird's eye view, not a detailed examination. And what I've looked at is the legal challenges which argued that COVID-19 regulations or executive orders made by Australian governments were invalid or unlawful. Internationally, previous studies which have reviewed the cases across the world have argued that there was substantial deference by the courts to measures taken by the legislative and executive branches. And we see a similar thing in Australia. So we'll start off by looking at jurisdictions with no Human Rights Act. So Kassam and Hazard involved a challenge to New South Wales public health orders, which required authorised workers to be vaccinated in order to leave a specified area for work. And there's a right at common law to bodily integrity, and that's an individual's right to choose what occurs with respect to his or her own person. And the court held that the directions did not interfere with that common law right to bodily integrity because they did not authorise involuntary vaccination. There was still a choice, but instead the correct analysis was that they curtailed freedom of movement because they prevented people from moving to work if they weren't vaccinated. The New South Wales Supreme Court held that the restrictions were within the scope of the powers conferred by the empowering statute and they were not unreasonable, and an appeal was dismissed by the Court of Appeal. Lata and Hazard concerned a challenge to public health orders which prohibited the applicant from working as a paramedic unless vaccinated. And the court held that the scope of the order was reasonable for reasons which included the risks posed by the virus, its transmissibility, and the relative inefficacy of the vaccine to protect vulnerable persons. And a recurring theme in this decision is that the relevant powers were conferred on the executive, and so it's for the executive to weigh the risks posed by the pandemic and the relevant interests, and it's not for the court to substitute its own view as to what the preferable decision was. Varnhagen also concerned a challenge to mandatory vaccination directions. This case mostly turned on technical questions of statutory construction. So the legislation was amended and a new set of powers or provisions relating to COVID-19 were inserted into the legislation. And the question was, what was the effect of the transitional provisions on the validity of the directions? The court held that the effect of the amending legislation was to continue enforce the directions. The case was dismissed and an appeal was dismissed. And finally, for this bracket, the Supreme Court of Western Australia determined 3 matters also relating to mandatory vaccination. I won't go into all the details, but one of the directions was a direction issued by the Commissioner of Police which required police officers and employees to be vaccinated. So it was a much more direct infringement on the right of bodily integrity. So the Western Australian Supreme Court and the Court of Appeal held that the direction did infringe the right to bodily integrity because there was no real or genuine choice as to whether to become vaccinated. but that the Chief Commissioner necessarily possessed such a power, given the disciplined and hierarchical nature of the police force. Okay, so that's the cases in jurisdictions without a Human Rights Act. How did things fare in jurisdictions with Human Rights Acts? Well, there are two main cases. There's Loyello and Giles. If anyone can correct my pronunciation, happy to hear it. But this concerned a challenge to a curfew imposed on Melbourne residents. So the challenge was based on judicial review grounds as well as the Charter Act, but it was rejected. The directions significantly restricted movement, but did not directly engage the right to liberty because the applicant was not subject to arbitrary arrest or detention. And Justice Ginnane noted that determining unlawfulness under the Charter Act requires a greater intensity of review, but held that the curfew was reasonably necessary to protect public health and there were no other reasonably available means to achieve the purpose of reducing infections. So that's the Victorian case. Then we have Johnson and Carroll. And this case was a Queensland challenge to directions that police officers and staff, as well as employees of the Queensland Ambulance Service, had to be vaccinated against COVID, which they were heard together. And this challenge was successful. But before you get too excited, it's worth bearing in mind that this was invalidated on the procedural limb. So remember that public entities need to give proper consideration to human rights that might be affected by their decisions when making decisions and exercising power. And in this case, the Commissioner made her decision before receiving advice on the human rights impact of the directions. In other words, it would be fairly easy to circumvent this in future. So as all cases do, this case turned on the facts, and the judge was very critical of the Commissioner. I wouldn't say it's entertaining, but it's somewhat amusing to read the judge's comments. So for example, the judge said, the Commissioner was cross-examined in detail about the process which led to her making the direction. Unfortunately, she did not appear to have given her evidence much thought before she entered the witness box. Her recollection was poor, and she seemed to be unfamiliar with some of the documents which were at the heart of the case. She frequently had to peruse documents, sometimes at length, and sometimes when she was being asked questions unrelated to any documents. So that's the procedural limb. In terms of the substantive limb, the court held that the directions limited the right not to be subjected to medical or scientific experimentation or treatment without full, free and informed consent, but that this limit was demonstrably justified. So the finding in this case then is probably cold comfort, depending of course on your point of view. It would arguably not be particularly difficult to avoid unlawfulness on this ground in the future. I'll just briefly mention a few more cases. One is the case of Atharval in New South Wales. And this was an unsuccessful application for an injunction to restrain the Commonwealth, Victoria and New South Wales from preventing them from celebrating religious observances of Rosh Hashanah and Yom Kippur in 2021. No reliance was placed on the Charter Act in relation to the Victorian directions. I wonder why. And that challenge was unsuccessful. And then just briefly, three more cases which were based on rights and freedoms in the Commonwealth Constitution. So Gurner and Victoria. In this case, the plaintiff challenged Victorian lockdown directions which restricted movement and the ability to gather in public places. And the challenge was based on the implied constitutional guarantee of freedom of movement. And the High Court held that there is no basis in the text or structure of the Constitution for such an implied freedom of intrastate movement. Cotterell was a challenge based on the implied freedom of political communication, and it was held that the directions did not impermissibly burden the implied freedom. The emergency directions did burden the freedom, but did so for a legitimate purpose, namely reducing serious risk to public health in the context of an emergency, and they did so in a proportionate manner. And then finally, Clive Palmer's challenge to the Western Australian border closure on the ground that it infringed an express right in the Constitution, namely Section 92. And the High Court held that the burden on interstate intercourse effected by the relevant legislative provisions was justified as it went no further than reasonably necessary to achieve the legitimate purpose of protecting life and health, and so was consistent with Section 92. And so these latter two cases, Palmer and Cotterill, they illustrate that even where there is a judicially enforceable right expressly contained in the Constitution or implied in the Constitution, but under a long-standing stream of case law, the courts will rarely invalidate laws, and they won't do so if it can be shown that they pursue a legitimate goal in a proportionate manner. Okay, so there are three things that I wanted to draw from these decisions. The first one is in relation to the interpretation of legislation. And so the first point I wanted to make is that one of the key issues that the courts had to confront was the interpretation of broadly framed public health or emergency powers, which conferred broad authority on executive decision makers. So how were these interpreted, and what difference did the interpretive mandates in the Human Rights Acts make? And this can be illustrated by two cases. So in the New South Wales case of Kassam, where there is no Charter of Rights, the court refused to read down a broadly framed power based on the principle of legality, holding that the principle of legality has a limited role to play where the provisions of a statute expressly contemplate that particular rights will be curtailed. And in the Queensland case of Johnson, where there is a Charter of Rights, the Queensland Supreme Court held that the interpretive mandate in the Human Rights Act cannot readily be applied to restrict open-ended discretions because that would invite the court to stray from its interpretive role and engage in a more legislative task. So that is, in jurisdictions with Human Rights Acts, as well as those without, courts have eagerly adopted expansive constructions of the emergency powers and generally adopting a high level of deference to the executive in rejecting such arguments, to quote my colleague Bruce Chen. In other words, Human Rights Acts did not lead to more rights-favourable interpretations of legislation in the COVID cases. Second thing I wanted to comment on was the obligations of public authorities. And so the cases that I've referred to involved judicial review challenges to the exercise of power by the executive under public health legislation. And as I've noted, the Human Rights Acts provide two additional grounds of challenge to those that are otherwise available, so a substantive and a procedural ground. I'll just briefly comment on the court's approach. So the procedural ground is that public entities must give proper consideration to human rights when making decisions. And the courts held that this should be done in a common sense and a practical manner, not expecting a level of judicial scrutiny. So the courts have said it should not be scrutinised overzealously. In other words, this seems to be a relatively undemanding obligation to satisfy. The substantive obligation or ground is that public entities must act in a way that is compatible with human rights. And that might appear to require a greater intensity of review, which is what the Victorian Supreme Court said. However, when determining whether an act of a public authority is incompatible with a human right, the courts apply that proportionality test. Human rights are not absolute and may be subject to limits which can be demonstrably justified in a free and democratic society, including whether there were any less restrictive means available which would achieve the relevant purpose. And as we've seen, there was no case which overturned a decision on the basis that it was incompatible with human rights. The final thing I wanted to comment on is that there is a recurring theme in these cases about a particular conception of the court's proper role, which is relevant to both legislative and executive action. In relation to legislation, the courts consider that to depart from the plain meaning of a piece of legislation in order to advance a more rights-favourable interpretation would be to stray from the court's proper role into a more legislative function. And in relation to executive action, the question for the court was whether the decision was made lawfully within relevant legal limits and within the range of reasonable decisions that could have been made, not whether the court thinks that the decision was the preferable or the best decision. And so, for example, in the Falconer case, the Western Australian Court of Appeal held that it is not for this court to consider the merit of the Commissioner's purported exercise of power in issuing the direction. And that, of course, is entirely orthodox and even unsurprising, but the key point for present purposes is that the existence of a Human Rights Act made little or no difference to the court's conception of their proper role. In the COVID cases, courts showed a significant level of deference to parliamentary intention and also the executive. Now, we're not supposed to have a doctrine of judicial deference in Australia, and so deference is probably not quite the right word. but it seems a reasonably accurate description of how the courts approached the COVID-19 cases. Okay, so in this paper, I've looked at the cases which involve challenges to COVID regulations, which involve the most severe restrictions on human rights in living memory imposed by Australian governments. I want to leave you with two thoughts. So the cases enable us to compare the human rights performance of jurisdictions with human rights acts compared to those without human rights acts, at least in one area, so legal challenges to executive directions. And the cases reveal that human rights acts made little difference to the manner in which the courts approach the questions of the interpretation of legislation and executive invalidity. In one case, a Queensland direction was invalidated because the Commissioner failed to give consideration to human rights when giving a direction to police. But in every other case, the existence of a Human Rights Act seemingly made little difference to the outcome or even the analysis, the process. The cases that suggest then that the fundamental contours of the Australian model of constitutionalism remain in place. Perhaps this does not mean that there is no value in a National Charter of Human Rights, but it might give us pause to consider claims that having a National Charter of Rights would lead to better protection of rights in Australia. And my final observation is as follows. So contemporary accounts of human rights typically articulate rights without reference to any kind of higher law or natural law, and certainly no reference to God. Human rights acts reflect the fundamentally political nature of important aspects of our constitutionalism. So that is, very few rights are absolute, rights often conflict with each other, and rights may be limited to serve other important policy goals. And it's a matter for the democratically elected branches of government to decide whether such limitations are justified. The problem with this is that it brings human rights within the political process, so that human rights and human rights protection are simply another product of the political process and not something above it. French sociologist Jacques Ellul, in his writings, described the dominance of technique in the modern world. Now, Jacques Ellul might have described human rights today as simply technique or method. They're simply an analytical tool with no reference to any objective moral order or higher reality. But in order for human rights to serve their purpose, they need to be untainted, as it were, by the fickle political realities of the democratic sausage machine. For human rights to be a standard against which to measure human laws, they need to be objective, unchanging, and grounded in a higher law, that is, the natural law. Thank you.